I was proposing to refer to but two examples of cases in the context of victimhood, but on reading the final version of today's program, I propose to refer to three. And if I take further time, I make no apology. That will avoid questions and we'll get to morning tea the more quickly. The first example I recall was in the Supreme Court and was prompted by the change in the program and involved the homicide of a 16-year-old heroin-addicted prostitute whose name was Jasmine. The offender was charged with murder and was convicted of manslaughter. And Jasmine had been young, a drug addict, and alone in the world. It was the one case in my career where sadly I thought the outcome had been affected and thus infected by prejudice against the identity of the victim on the part of the jury. I received a letter from what was then called, I think, the Sex Workers Cooperative, thanking me for making some remarks I thought were called for in sentencing the offender, that nothing turned on who or what Jasmine was. She was as human as any other victim of such a crime. The second example is a case of fratricide, the only one of them that I've ever had. Brother kills brother in a country town. And the awful reality of that case was that the death of one family member in effect was welcomed by all the others. It was an extraordinary case in which the message was, well, thank goodness we've got rid of this absolute pain in the neck. And coming onto the bench, I was confronted by the vision of one side of the public gallery being completely empty. And on the other side, it was completely full of all the family members of the accused. To my recollection, there was a plea of guilty to manslaughter, and the matter was disposed of to everyone's satisfaction, which is a rare occurrence. I wish to contrast that second example with the third and final one to which I wish to refer. And it was the last murder trial over which I presided before my retirement. The courtroom was packed at Darlinghurst with the family and supporters of the accused, of whom there were two on one side in the public section, and with the family and supporters of the survivors and the victim on the other. That each group came from different ethnic, geographical and socio-economic backgrounds was patent, and the tensions between them through the hearing was palpable. And as I, in the 5 or 6 years since, have from time to time done, I have reflected upon how much content in reality there is in the statement that our society is truly inclusive. At the end of the proceedings and after the findings of guilt by the jury, the victims made statements in open court before sentence. I must say, and can say, that my reactions ranged from a flush of discomfort, as if I was an intruder in the public expression of private grief, on the one hand, to what I like to consider to have been natural compassion, sadness and despair on the other. But in the end, having heard the statements read, in the atmosphere and ambience of that courtroom, I had to turn to my task, my judicial business of sentencing. From that last trial, two things relevant to the theme of this conference have flowed. First, I was asked by an academic at the University of Technology, Sydney, at which I happen to be an adjunct professor in the law faculty, asked me whether that part of the case before sentencing involving the victims making their statements orally amounted to the triangulation of the process, hence the reference to geometry in connection with the title for my address. And I reflected upon that question and answered it yes. Crown, convicted prisoners, victims. But that triangulation only lasted for the time and for the purpose of the victim's participation. And thereafter, the geometry reverted to the more prosaic, sterile but demanding task of sentencing by the trial judge. The second matter that followed from my last murder trial was that 2 or so years ago I attended a restorative justice event at Corrective Services, and in circumstances beyond my memory, that trial came up in conversation and might have been on my own initiative, because at that restorative justice event I had an awful realisation, and it was this: that I could remember the names of the accused in my last murder trial, but I could not remember the name of the victim. And what a sad commentary on the whole business of the administration of justice that represented for me. I can say I now remember both names. Before I move on to deal briefly with the Serious Offenders Review Council and victims, I'm sure I have your permission, and whether or not I do, I propose to be the slightly traditionalist, pensioned-off common law trial judge and say a couple of things as to expanding the role of juries or victims in the sentencing process. And I do so with as much diplomacy, discretion, good sense, etc., as is required, taking into account that what I'm about to say at present does not quite coincide with the views held by the Attorney-General. I am opposed to both, that is, the expanding of the role of juries and or victims in the sentencing process. Second, and this is close to the attorney's heart, I gather, in the case of the deceased victim, the law was settled in 1997 by the Chief Judge at Common Law, Mr. Justice David Hunt, in a case called Previtera, on sound jurisprudential principles and good common sense, which can be summed up that we're all equal before the law, alive or dead. I interrupt here to deal with a matter that's in the public domain on the issue of the identity of the deceased and whether or not there was a relationship between the victims and the event at the time, or the consequences by reason of the identity of the deceased and publicity and the status of victims. I think it was in 1991 Dr. Victor Chang was murdered, and the year before last, the first of his murderers was released to parole and deported. And as a citizen and as a retired judge, I was mortified by the unleashing of irrational outrage at those events, which included a statement reported in the press by a senior police officer that this murderer should stay in jail for he is responsible for the death of thousands by reason of the identity of his victim. I was horrified by that. And it represents and represented an irrational, emotional and uncontrolled and dangerous response to the presently in place due processes of the administration of justice. The Dr. Chang case is ideal for reading the remarks on sentence by a great judge, Mr. Justice Slattery, because it is not until about page 8 or 9 that His Honour first refers to the name of the deceased or the victim, let alone his standing as a cardiologist.